Start. Yeah. Ready to start. This week's sponsored by Logbook Brewing. Let's give a big hand to a brewery that approves of the spread of knowledge and scholarship. So. Today, I don't think we just need to get started because we're already running late. On Facebook, you can watch this on YouTube. Those of you who are actually here with us physically, please join us for our Pursuit of Happiness Now reception afterwards. To introduce today's speaker, I'd like to introduce my colleague, Al Burkhart, who's practiced singing praise saying, who is assistant professor of history.
Yes, to introduce our speaker today, Nora Slanimsky. She is the assistant professor of history as well as the director of the Institute of Thomas Paine Studies at Iona College, just outside New York in New Rochelle. She is obviously of things like IP, copyright, many other things, but she's also very much historian of early America. In the national period. She's held fellowships from all sorts of places that are familiar to us in that field. Fellowships from places like the New York Historical Society, the McNeil Center, the American Antiquarian Society, and many others. In terms of her work, very wide-ranging. She has had her book that's forthcoming, which is The Engine of Free Expression, Copyrighting the State in Early America, is forthcoming with Penn Press. In its stage when it was a dissertation, it won this year the Society for Historians of the Early American Republic Dissertation Prize. She has also published in addition to her other work, she's very active in organizing at the Institute of Paine Studies and a lot of other public things in education, helping people in the 12 as it relates to history concerns going forward today. But yeah, it's really my pleasure to have Nora here with us, and she'll be talking to us today about copyright before copyright.
Better? Yeah, okay, great. First tech issue is good to go. Thank you so much to Al, to Jeff, and to everyone. Is that echo okay? No, let me does that help at all? Is that a little less? Yeah, okay. Thank you to Jeff and Al and everyone at Kinder for having me here today. It's really wonderful to be here with you all. It's a bit surreal. I haven't been talking in person yet, so this is, again, very cool. And also, obviously, for everyone who's here, lineup of content this year, so in the past few weeks alone, copyright has been back in the news with headlines like "The Bad Art Friend." Does anyone follow that story? Check it out. It's pretty interesting. Former President Trump's controversial or issue going on right now with Eddie Grant and Electric Avenue and his campaign videos. And for anyone who's going to be watching Friday the 13th next weekend, that's also in the midst of a copyright dispute. So copyright's in a lot of places that you wouldn't normally or always think of, and that's what I think makes it a pretty interesting subject. Rights are at once creative, but also explicitly commercial and political. Right? It's not just about society works, but multiple at the same time. Copyright today is one of 4 forms of intellectual property that result from intellectual work, right? Anything that you do with your mind, and how that translates into all the ones we've heard of: patents, copyrights, trademarks, and trade secrets. And they're in and of themselves. They come from a bundle or a constellation of rights that come with them. So things like derivative rights and spin-offs, and oh gosh, there's just too many to count. Copyright in the early Republic and in early America writ large was a bit more straightforward. It means pretty much exactly what it sounds like. It's the right to make copies. the right to control the reproduction of your work. But it was also no less complicated politically or commercially several hundred years ago, probably no surprise to anyone here. When copyright first formally emerges in the early 18th century in England, it's a response to the breakdown of the Tudor and Stuart monarchical censorship regimes, the oversight of the Stationers' Company, which was a printing guild, and increased interest in copyright, its common law counterpart, literary property. So in other words, copyright was the thing that was guaranteed to you by law. It was explicit, it had an end date, a sort of a consolidated term, but literary property or textual property was intrinsic. It was the thing that when you did the work, it was connected to you, it was the output of your labor, and so you were entitled to some kind of connection to it, some kind of compensation for it. And that's really the genesis of what we call IP today. It was an extension, it was rather the expression of a work or quote, the fruits of one's labor that was compensated, not the idea itself, and that's an important distinction, and I'm going to get to a little bit more of why that matters in a few minutes. Even though that is a bit of a murky distinction, it's one that holds through the present day. For example, that's why news stories are not copyrighted, or ostensibly not copyrighted in the 21st century. So it was against this backdrop, though, that copyright slowly developed in North America, formally in the British colonies, and at state and then national level. There's been really tremendous scholarship from Orrin Braca, Meredith McGill, Will Slaughter, and many others. Copyright's a subject that's studied by legal scholars, literary scholars, historians, really across the board. And they've traced how the development of copyright law and practice really kicks up in the 19th century, meaning it's usually a 19th and 20th century phenomenon, because in the earlier years, copyright didn't work very well. It was not the dominant or most effective practice that it would eventually come to be. For example, in 2016, there was a major census study that said that nearly 35% of the United States economy was tied to IP-intensive industries, meaning people that make a lot of their money on forms of intellectual property. That is not the case in early America. It's probably a negligible aspect of the economy in its early input, and yet no less significant because of the attempts to try to make it work. And it's those attempts to try to make it work that I'm interested in and that I am going to try to talk to you about today. That worked? No, that did not work. Hold on. Yes, okay, great. Now it's working. Perfect, okay. So when I first started working on my project, and Al's really kind introduction described to you what it is as a dissertating student, which feels about 735 years ago at this point, I was really interested in, frankly, a sentence from a 1985 Supreme Court case. And in that sentence, in the majority opinion, Supreme Court Justice, former Justice Sandra Day O'Connor, wrote that copyright was designed to be the engine of free expression, that the framers of the Constitution, that's how they thought about it. And I was like, I didn't think the framers thought about copyright at all. So that's an interesting thing. I'd like to learn some more about that. And that prompted me sort of down the rabbit hole that's consumed the last decade of my life. But what I did find in the course of this process was, or the original pursuit that I was interested in, which was, are there partisan dimensions? In the first rise of political parties in the United States, are there partisan dimensions to what copyright was? And there are partisan dimensions to it, but the story that I ultimately began to tell and what's my work today is focused on is more the little f federalism rather than the capital F Federalist Party. In other words, how did the system of governance that we still live under today, how did that system of government create its relationship, or was created by a relationship with copyright, small though significant that it was. So in my book manuscript, which is the engine of free expression, the O'Connor quote has stuck with me, Copywriting the State in Early America, I argue that copyright was a subtle but meaningful aspect of state formation, as much, if not more so, about that little f federalism than the capital F Federalists. One of the many things, again, that surprised me over the course of this research was that it's actually a story that starts before the early republic, from my point of view, embedded in many of the same debates and tensions that lead to independence itself. because the most frequent form of source material, and I had a really lovely lunch with some grad students from Mizzou earlier today, and we were talking a lot about source material, right, and how you unpack an archive, how you figure out who's there, who's missing, who's absent. And those were questions that I've been really focused on too. Most of the copyright evidence that we think about lies in court cases and official registration, and I would be remiss if I didn't shout out the Library of Congress has recently launched an incredible digitization project of these early registrations, and Zvi Rosen in particular has been wonderful in his work there. And to be very clear, I use those resources as well and rely on them very much. But I take a much wider lens to what copyright is, and I try to go beyond understanding of copyright that is that formal, limited statutory procedure, and think about how people, well, literally, how do people think about copyright? How do they talk about it? How do they understand it? And more broadly, what did that mean for how they saw ownership over themselves? How did they see that in relation to producing property? And finally, how did they see that in relationship with their government apparatus, like state authority, right? Whether that was on the local level, first the colonial level, different assemblies, local governance, imperial governance, and then moving forward, state level government, and then national government. So rather than focusing on one case study or one vignette today, which would probably be a lot easier for everyone in the audience to follow, I want to give you first a brief background that sets the foundation of this big argument, right? Of how copyright becomes both this tool and product, or as the title of my talk today, how authorship in effect becomes both a way of authorizing one's sort of legitimacy over their work by claiming this status as author, right? Because author and writer are not quite the same thing, right? Author is sort of a legally recognized public thing that you get property rights from, whereas a writer is a bit murkier and harder to parse out. And in turn, how that process of authors sort of claiming authority over their work, sometimes inadvertently and sometimes deliberately, involves itself in this process of state formation. And the three major episodes that I want to share with you, I think, highlight different parts about how this process works, or different ways in which this process works, this authorizing authorship, if you will. So the way that I really look at this, I should say, in the earlier period, or the period before the United States becomes the United States, is this idea about copyright consciousness. Again, in other words, just because people might not have the words or the sort of technical descriptions for the processes that they're dealing with, how are they thinking about it, or how are they trying to access it, even if it's across the Atlantic Ocean? And there's a couple of, I think, really illustrative examples of how this works. Copyright, like so many other rights in the 18th century, it was unclear whether or not this extended to across the British Empire, right? It was clear that this extended to people who lived in England. If you were a British subject who lived on English soil, and very specifically English soil, it was not clear, for example, if you lived in Scotland, if this applied to you. Then copyright was a fairly clear-cut procedure in which you could engage with, in which you could draw upon. When I say clear-cut, that doesn't mean it wasn't totally mirrored in debate, or mired in debate and discussion, of course it was, but your actual right to have it was clear, right? That wasn't up for debate. But if you lived in other parts of the British Empire, like many other rights, this was not certain, this was not established. And in one of these particular examples, you can see that first one up there in the top corner is a pretty famous map by the geographer Lewis Evans, which is published in 1755. And this is one of the earliest examples that I found in my work. And to be clear, there are other examples of things that we might say as like are adjacent to intellectual property, like an exclusive privilege, like someone in a patronage system, like a governor gives someone an exclusive right to print something. There are examples of that. But this is the first example I have found where someone is actively describing what they're doing as a copyright, where they're actively saying that's what they're pursuing. And Evans, and what you can see highlighted in that little red box there, but actually is in the bottom right corner of the map, is tantamount to a copyright notice. The C symbol that is fairly ubiquitous today, even though I should say it is not technically necessary today in the same way. That's what it looked like in the mid-18th century. It was a statement saying that you, under the Act of Parliament, which was a sort of a known flag for the Statute of Anne, which is the first modern copyright law, that you had done the steps that you had to do, and now you had a copyright over your map. Lewis Evans did not have a copyright over his map in the sense that it would never have been held up in court that he actually had the ability to have a copyright for this map. And this is because the map is made in Philadelphia. And there are no copyright laws in Philadelphia. Evans does something kind of similar. He petitions the Pennsylvania Assembly, asking for recognition, asking for money to help him make this map, but patronage, right, and copyright are not quite the same thing, although there's some overlap. But he puts this stamp on his map, or this notice on his map, in effect as a way to ward off would-be pirates, or people who might not know that he doesn't technically have the right that he says he does. And the very fact that he's doing this on a map is also very interesting because it is not clear in the 1750s if maps are even copyrightable. And this comes back to that expression versus ideas thing, right? If you're technically just describing what's in nature, then that's not an interpretation, right? That's supposed to be, of course, this is wildly interpretive. But that's sort of the challenge. And if anyone's interested in copyright and maps, Isabella Alexander has a phenomenal, is doing phenomenal research on it in the English context. But anyway, this is one example where he distinguishes on that stamp and in his correspondence with a London publisher trying to get a London edition, that these are two competing spaces and that none of the maps he negotiates for in England can be sent to America because that would compete with the situation and the rights he's established in Pennsylvania. Again, it's against this backdrop that copyright starts to pop up in other places in the 1760s and 1770s. You have Margaret Price, who sues her erstwhile fiance for breach of contract when he does not marry her when he's supposed to, and for theft of property. And she writes about, in her words, this good for nothing, in very detailed letters that are read in the court when this trial takes place. And the letters are so compelling that a printer in New York, unfortunately, this notice does not say who that printer was, offers her money to print her letters and knows that he has to offer her a copyright for them. So you see it popping up in relationship spats. It comes up very formally, actually, with the hymnodist or musician, William Billings, who petitions the Massachusetts Assembly in the 1770s for a copyright for his book of hymns, the New England Psalm Singer. Paul Revere is the famous engraver of that front piece image, which is probably one of the most valuable parts of the book. And he's denied. Well, the Assembly wants to give him the copyright. The Assembly approves it, and then the Imperial Governor, Thomas Hutchinson, denies the request on the grounds that we can assume that the copyright would not be legitimate, again, because Billings is a colonist and not someone who resides in England. And yet, in another layer, or another sort of wrinkle to this story, and in the sort of increasingly, a long overdue increasing attention has been paid to Phyllis Wheatley and her publishing experiences with her poems on miscellaneous subjects. And when Wheatley famously resided in colonies and could not find an American publisher, she journeyed with the family who had enslaved her to London, where she arranged with Archibald Bell. And I apologize, I'm going through these stories a little bit quickly. And Bell, as you can see under the front piece, under her famous portrait, did arrange for a copyright for himself, the printer, a bookseller in England. However, when Wheatley comes back to the United States, she writes, and I have to also thank David Wallstreicher for this reference, Wheatley writes to a colleague, if you will, in the colonies, someone who's involved in broader trade and importation of items into Connecticut, in particular in Massachusetts. And she describes how because she has just become emancipated and she's no longer enslaved, her book is the only property that's her own. That the book is what she has made, it's her only source of income, and asks him in no uncertain terms to not allow for reprinting or to not publish unauthorized editions because this is the source of her income and it will prove an issue with Bell back in London. And she ties quite explicitly her emancipation and her ability to own literary property. She's able to own this now because she now owns herself. And this is in contrast to an episode that happens shortly after independence with the poet and writer Jupiter Hammond. And Jupiter Hammond, who remains enslaved for the entirety of his life, does not have any access to copyright. does not have any access to any kind of intellectual ownership because he does not legally have the status of owning himself. And moreover, has to verify that he is in fact the writer. He has to authorize his own authorship, if you will, because of the doubts that are levied against him as an enslaved person. So all of these different ingredients, if you will, taken together, set the stage for what's going to emerge in the wake of independence. In other words, independence, as much as I would love to say was driven by disputes over copyright, the revolution was not regrettably about copyright entirely. But there is a case to be made that many of the issues at stake in copyright, nascent though it was, are very much in line and overlapping and connecting with these broader subjects that are well studied and well and get a fair amount of attention. This copyright consciousness, as I just described it, is part of why Georgetown has not even been fought yet, and there are petitions coming in to different local governments. Connecticut, for example, the first copyright officially is given to another composer named Andrew Law in Connecticut in October of 1782. So it is on the minds of people, granted people who are further away from military conflict at that point, but it is very much on their minds. Joe Barlow, for example, another writer, writes a very compelling and arresting letter where he's like, I know we had to worry, I'm paraphrasing, I apologize. I know we had to worry about the war, but now that the war is done, we need a national literature. We need a civic, communications. We really got to distinguish ourselves here, so can you help me out? To which the Continental Congress is like, unfortunately, no, we can't help you out. We do not have the authority to pass any national legislation that would protect copyright. So copyright consciousness in the early republic, or this very early days of the early republic, basically boils down to three major issues. And the first is jurisdiction, right? In the first place, right, there is a process of recognition. A writer recognizes or does not recognize the jurisdictional authority of a government to authorize, in effect, their copyright, right? Billings recognized the authority of the Massachusetts Assembly to his copyright. He did not recognize the authority of Governor Hutchinson, right? So he chose, in that sense, which authority he was selecting and which he was going to, I guess, enter into business with, for lack of a better word. But that structure of authority, in turn, has to recognize copyright back in order to actually make it enforceable, right? It's this mutually beneficial, at times, sometimes not so beneficial, relationship that you enter into. And who has the jurisdiction, in other words, to oversee it, is not a resolved or clear-cut issue. And the second thread of this is really reputation and social purpose. Part of that process of how a writer and their labor becomes a public legal figure, right, of author, and I won't regale everyone with like Foucault and what is an author. There's a great quote, and I'm mortified, I'm gonna have to follow up once I've been able to check the author, but a legal historian wrote that Foucault, responding to Foucault, no, the author isn't dead, they just got a job. And I cannot believe I didn't write down their name. I'm mortified. Bad talk for copyright to not remember the name. But I will follow up and I will share it. But that is in effect what's happening, right? The author is getting a job in this framework. And part of how they get that job is because they've established the right to do it, right? You want to buy their work, you want to participate in their process because they are an expert, they have some kind of crafted or cultivated form of authority, whether or not we think that they have it, right? Or we think that their self-fashioning is valid is kind of a whole other project for someone else to do, which would be great, but not really the concern of this one. And as well as it boils down for very directly for Wheatley and Hammond, their self-ownership, right? Their ownership over themselves and the work they have to do on top of what most writers do, which is cultivating, again, this reputation, is being like, claiming the property for themselves when they have been dehumanized and treated as property. A really key way in which they do this is this language of civic purpose. That the expression, right, an expression can be a book, a pamphlet, a print, anything that you physically commit to in this period anyway, something that's printable, that can be reproduced by a printing press, is just central to this idea of civic duty, right? That they're like, my map serves the British Imperial Project. Whether or not you think that it does, something else, right? my poems are a celebration of Columbia, right? That they're tied to this nation, what will become a nation building project is also a really key part of this expertise. And the third part really just boils down to ownership, right? That the status of author was thoroughly linked to self-ownership is one part of it, but it is this pathway for claiming rights from government as well as affecting or pushing for recognition that then the government has to support you with, because copyrights are not the same thing as other forms of property and do require that oversight to be able to function effectively. Again, one of these many constituent processes in which copyright was both a tool and a product of this process of the US nation state forming. However, most people who are involved in copyright, despite the fact that I've spent probably the last 15 minutes talking to you about writers, are actually printers. In other words, the bulk of the people in England who own copyrights or buy up copyrights, the Stationers Guild is a printers and booksellers, I shouldn't say, guild, right? They make arguments on behalf of, and I should say this is not my argument, this has been done by incredible, like Mark Rose and other writers who have really studied this in detail, that they use the language of authorship and apply it to proprietorship. In other words, they will buy out the rights from writers as printers, the ones who hold the access to the technology in all of its forms. So Elizabeth Holt enters the scene, if you will, not as an author or a writer and would not identify as such, but as a proprietor, mainly, and as a printer. Her husband, John Holt, is a well-studied figure right of the Revolutionary period for his involvement in the print trade as well as in pro-revolutionary publication. When John Holt dies, Elizabeth Holt quite literally, and I'm thinking actually Stephen Carl Smith, who I know is an alum of this program, has a great section on this process in his book. And Elizabeth Holt quite literally takes over the business from him because there aren't very many options, right? It's that or she will have no money. And in doing so, she also takes over his title as printer of the state. And this is this really interesting moment where patronage and what we call as sort of imperial processes by which texts get circulated that are considered sort of socially necessary, i.e. like laws or other kinds of official documents. Going back to New York in 1750, in the 1750s is the first printing privilege by the New York State Assembly to printers to produce the laws, and amongst other things, but the laws are really one of the primary objectives. So Elizabeth Holt takes over this rather exclusive, this really coveted arrangement, and also with it this title, and she becomes the printer to the state, as you can see, both on publication of the laws, as well as when she takes over her husband's newspaper, and she, by every estimation, in a very limited, once again, surviving material we have about her, holds on to this title very intensely until it is taken from her or she loses the contract in favor of another printer, Samuel Woodham. She spends, though, a fair amount of time petitioning the New York State Assembly, both for back pay under this position. Tantalizingly and extremely frustratingly, there is a very devastating fire in the New York State Capitol in 1911. And all the records that related to Holt's petitioning, for the most part, are gone. And in particular, that relate to the law, and I can only hypothesize here, there's absolutely no way you can prove it, but I do think it's interesting to think about how gender is also a part of this process. Around the same time that Elizabeth Holt is in the surviving records that her replacement actually prints, which is the levels of irony there, we know that she's petitioning for, again, back pay and for back recognition for the work she did as printer of the state, is the same time that an act to promote literature appears in the minutes. And at this point, with the exception, I believe Delaware is the only state that does not pass a Copyright Act before the Constitution is ratified in 1787, but in the absence of the Continental Congress or the Confederation Congress's ability to pass a national copyright law, states begin to do so. And it is really fascinating how different they are. If there's some kind of consensus or general statement on what copyright is or what it's supposed to do, these laws do not tell that story. In fact, they show a very complicated, convoluted, contradictory interpretation of what was going on in England for the previous 60 or 70 years. And the New York state law is in some ways perhaps the strangest, if you will, the most confounding of them all. And I apologize, the color is not really showing up on the slide, but I can just share with you a few major highlights of why this law is unusual. It is the only copyright law passed in this period that genders authorship as both male and female. Throughout the law, it is his and hers, not just his, which is every other law passed in this period genders authorship. Again, the legal recognition of writer, and that's the way that I engage with authorship in my work, as male, and this law doesn't. And again, there's simply no way of knowing if Holt has anything to do with that. I don't want to make the claim that that's what I'm saying. I wish I could, but I can't. And I've really relied heavily on Carolyn Steadman's work, as well as Marissa Fuentes, and how to sort of begin to figure out how you can work through some of this evidence that you do have. But that's not the only thing that's unusual about this act to promote literature. If you'll give me a moment, I will read you just a few clips from it. The prologue says that it's, quote, agreeable to the principles of natural equity and justice that every author should be secured in receiving the profits that may arise from the sale of his or her works. In addition to that very sort of flowery sentiment about equity and sort of the natural justice of having literary property, the law also creates a price stabilization, meaning if a printer or publisher or bookseller, right, use a cluster of words of different terms in the period, make a book too expensive, that the average person cannot afford it, the New York State Assembly in effect reserves the right to price stabilize, or they will lose the copyright if they don't make the price affordable. Yet another aspect of this is they fold in a land grant for education. Copyright is very quickly, if it hasn't already, becoming tied together again with this notion of civic good, of how to support and benefit your community, which is very starkly different than in some respects how a lot of IP doctrine is talked about today, right, which is very individually focused, whether that individual is a corporation or a person. That's quite a dramatic rhetorical framing than its earlier days. And then in perhaps the most confounding part of all is a libel cancellation. In other words, if your work is deemed as critical to the New York State government, and they're only concerned if you're critical about New York State, you can talk whatever you want about any other state, but not New York, which if anyone's spent time in New York, that sounds pretty, I'm a New Yorker, so I feel like I can say that sounds pretty accurate. Your copyright is voided. Yeah, your copyright is voided by libel. This is really fascinating, and that would be a whole other talk, but just something to put out there. All of which is to say, it's hard to be sure, again, what Holt's role was or was not in this, but that there is something happening in this period where exactly what copyright's relationship to the state via individual writers is supposed to be is very much up for grabs. It's very much a topic of discussion. The big takeaway is that civic belonging, who's included, and the reputation of government, right? That's not just the individual's reputation that's at stake here with some of these publications, but the reputation of the government itself. You really see that with publication of the laws, right? Kind of raises the question of who is literary property supposed to serve and what is it supposed to do? And this brings me to the second of the three examples, which is Jedidiah Morse, the quote-unquote father of American geography, who is perhaps, in my work anyway, is one of the figures that looms the largest because he is definitely one of the loudest about copyright. He is, along with Noah Webster, who's another famed figure in this period, applying similar tactics to Morse. He is very much fairly explicit. In some ways, a lot of the evidence I see is implicit, right? But he is quite explicit that his copyright is connected to his role as an authority figure, right? That his status as an author, specifically a geographer, and I use the term author in this talk, but many of these figures would have identified very specifically by the type or genre that they were doing, right? If you were a geographer, a poet, a hypnotist, that would be very akin to sort of the language you'd be using. But Jedidiah Morse begins his geographic publication career, if you will, in the 1780s. He is one of the first people to be petitioning in petitions that were actually lost, but were only found, I shouldn't say lost, were unknown to have been kept. I guess that is lost. In Connecticut, for example, until very recently, there was understanding that all the attempts to get many of the attempts to get copyrights were missing, but they were actually just logged in the Connecticut Land Book. And this is another shout out to Zvi Rosen and his colleagues who Bill and Kristen Keegan, who've done a lot of this research, but they were just in the land book because the person was like, oh, it's land, it's property, it's the same thing. We'll put the copyrights with the land because it's owning something. So nobody thought to look in the land books, but there they are, and Morse is the first name on the list, asking for various copyrights, as are many other map makers and geographers, and that's also probably why they chose to log them there. But he very acutely and early on in his career connects his role as a geographer of the United States. He references Lewis Evans very frequently, for example, as well as Thomas Hutchins, another earlier geographer, as part of sort of his civic duty, right, is to attach the youth of America, sort of the importance and quotes of their own country, and that these books and these maps would serve and charts as well, would serve this really critical role in attaching you quite literally to the physical composition of your country, right? That's sort of what his mission was. It was bluntly stated, repeatedly stated, and copyright was the means in which he could do it. If he was not paid for his work, he could not continue to do his work. It's worth noting he also had another job. He was a minister. He was an ordained minister. And in fact, his focus on his geographic work was really a thorn in the side of his congregation for a very long time, and he was very frequently criticized that he cared more about his geographic work than he did about tending to his flock, which ultimately in his older age led him to be removed as minister of his church. But he's deeply committed to this work, and he sees copyright as being the sort of complete and utter extension of it. However, he's also apparently very difficult to deal with if you believe the letters and contracts and correspondence of his longtime printers, Isaiah Thomas and Ebenezer Andrews, who basically describe in so many words that Morse is a man who loves money and knows how to get it. The direct quote. So he's acutely aware of the commercial and the political, but he just simply does not distinguish them as being sort of separate entities, right? They're bound together. This is what he needs to do. And he becomes a very early advocate or lobbyist, really, to once the Constitution is passed and the federal government is officially formed, he's one of the first people there petitioning for a copyright law. One of the loudest, it comes up, he comes up very frequently in those records as being the person who says copyright is necessary to advance the good of the country. This is necessary to do. He writes to Washington. Washington echoes this as well in his records. So Morse is very much a much more, I would say, obvious person who is involved in this relationship with federalism. It's also not probably a coincidence that Morse is a very early on identifies very passionately with the Federalist Coalition, the Federalist Party, and by extension, over the course of his copyright experience, many of his collaborations, if you will, tend to be with other figures in the Federalist Party. For example, Morse is at the heart of what's at this point considered the first federal copyright suit, where Alexander Hamilton serves as his lawyer, rendering Hamilton, in another sort of, again, complicated way, one of the first federal copyright lawyers. Almost by accident, but nonetheless, that is what happens. So unlike Holt or the other figures we looked at, right, he is very directly linked. But part of where this is also complicated, as later disputes with someone like Hannah Adams is going to show, and other fallouts over the course of his personal life, is that Morse's work is not entirely Morse's, right? That Morse's geography is, right? They're full of maps. And so Morse did not design his own maps, he did not engrave them, he did not draw them, and yet he's claiming in totality the property of these books, which he then frequently will sell to his printers. He sells the copyright in the books of stock, right, to the Thomas and Andrews at various points. But as you can see here, he openly cites map makers that he works with. Amos Doolittle, who's one of the most famous engravers of this period, this early Republican period, collaborates with him. But it's largely in what today we would call a work-for-hire relationship. And work-for-hire is an aspect of IP doctrine in which there's two ways that you basically lose that inherent right to your labor, if you will. And the first is that you are an employee of a company, or for that matter, another chapter in my book, I look at this in the context of the federal government. If you're a federal employee, do you still have the copyright to your work? And by the 1820s, the answer is like, probably not. So if your employment, your salary is what pays you, right? Not your copyright. So it takes the place. And the other way you forfeit or give up that inherent right is if you contract with someone else for a part of a bigger work. So if you're someone who's like an illustrator or anyone who's doing image work that's going to be part of a bigger book, right? The primary writer, in quotes, will probably buy that off from you, and that is what Morse does. But it also shows you again that this is not as clear cut as we might think, and that language is reflected in what becomes the first Federal Copyright Act of 1790, which is actually called an Act for the Encouragement of Learning. And throughout that law, you see this attempt to balance, and I should also say, if I didn't say it already, it draws on the US Constitution, which has a clause for the promoting of science and useful arts, which is what is the wellspring for the Copyright Act. But it in effect says that copyright is to provide a limited proprietary right for writers and other useful arts, again, utility is a big theme here, in exchange for the civic benefit that people are going to get from it. And this paves the way then for the third figure that I'll wrap up with today, which is a man named Peter Williams. And Peter Williams is the son of a revolutionary soldier, a man who serves the American Revolution, who becomes emancipated. And Williams is born free. He's born free in New York, and receives a very extensive education as a result of that status, and becomes a very prominent Black leader in the New York First Emancipation Movement. He is a minister amongst many other hats that he wears, and he's also a figure who is acutely aware of, guessed it, literary property, and what that means not only for himself as a writer and for his relationship to the federal government, which is now at this point that those federal laws have supplanted those local laws, right, in terms of the authority, that jurisdictional pull, that the Federal Copyright Act provides more extensive protection. Because if your book moves across the state line, then you're still covered. But also what it means for the particular cause that he is advocating for, which in this particular publication is abolition. And so, yeah, so I'm gonna pause there for one moment. Sorry, I'm just gonna grab a quick water and sip this place. But yes, so on the 1-year anniversary of the abolition of the slave trade in 1807, Williams presents an oration on the abolition of the slave trade, which is a 1-year commemoration of that momentous moment, and frankly, and again, one of these major acts in the history of federal authority in terms of how it follows through on the initial compromises of the late 1780s. And in this oration, amongst many other things that he describes, he is quite explicit about the legacy of independence and what that means both for him personally, as well as both enslaved and free people of color around the United States. And I'll spare you my reading of it, but as you can see here, his message is quite clear in what he is advocating for in an oration, and amongst other things, what he's also very passionate about And for anyone who's interested in more of this work, Paul Polgar's most recent book is really fantastic on this. It's about education and the importance of education as a critical way for, again, free and enslaved people of color, for Black Americans to begin to access the rights that are otherwise denied to them. Amongst the other things that he does, though, is this oration is rather quickly determined that it's going to go to print, and he arranges with Samuel Wood, who is a Quaker and a fairly well-established anti-slavery printer in New York at that time, to produce this work. Before it even comes to sale, however, Williams receives a tremendous amount of pushback. The rumors begin to swirl that are designed to discredit him, in no small part that he didn't actually write this. That once again, as a Black writer, it could not possibly have been his work. And the next step, of course, from that is saying that that is in fact plagiarism then, because if he didn't write it, who did, right? And this is how Williams chooses to respond. It's also worth noting that by 1807, there had been a second addendum to the Copyright Act, the Copyright Act of 1802, the Copyright Addendum, of 1802, in which case there was additional requirements put into place, one of which was the newspaper advertisements, that you had to advertise more explicitly and more extensively when you had a copyright for something, because how else would other printers know that it was under copyright if they didn't read it in the newspaper? In addition to the declaration that you saw on the previous slide, that the copyright statement was there. So Williams arranges for other colleagues, all white colleagues in the anti-slavery movement, to in effect vouch for him. And as he says here, and I will read this one, having understood that some persons doubt my being the author of this oration and thinking it probable that a like sentiment may be entertained by others who humor this publication with a perusal, I have thought proper to authenticate the fact by subjoining the following certificates. So Williams's authority as a writer, he has to bear the additional burden of authenticity. Morse, it's worth noting, is accused of being sloppy. He's accused of being partisan, particularly by rival factions, rival parties. There's a host of critiques. Even though Morse does, in fact, crib from other writers and does rely very heavily on the work of others, it's never a question that he has to authenticate his work. Williams does. And he does so very effectively and unapologetically, it's worth noting. So he meets this kind of double standard, for lack of another term, quite head on. And in doing so, in claiming this copyright, in situating himself as a citizen, as another aspect of the oration, he identifies quite strongly as a citizen. He writes this in the opening words. Copyright is a right of citizenship and technically residency. The Copyright Act does extend a degree of copyright protection to residents as well. But he's making a very explicit claim on the federal government, and because people are not really fact-checking copyright claims in this point, but even if they were to, he has the evidence to unequivocally say, you cannot deny me this right. And that I hope is a relatively effective note to wrap up on. Copyright before copyright then is very much about civic belonging, of who has access to certain rights and on what terms, and in turn how claiming those rights, in this instance, to make copies of expressions that are deeply tied to really important issues in the early republic. These threads really undergird, I think, how copyright went beyond this process, right, of just registration and infringement, and really sort of the establishment of federal authority itself. So thank you so much. I really appreciate your time. Did I slide out the other way? Oh, great.
So we're going to move to the Q&A section now, and so if we could start off with someone in the room, preferably with a student, move from there. If we have student questions, I'd like to.
Hi, I'm Max. I'm a master's student here. And I was just wondering, so you must be self-owning to have ownership over your intellectual property. How exactly was like the argument drawn, to whom did the property belong if any property was produced by a non-self-owning person? Where did it come from and who did it go to?
It's a great question. So in other words, if Jupiter Hammond couldn't own his copyright, who did? In effect, technically, I mean legally, under the terms of the law, that I should say, that was never adjudicated. So I don't have a clear-cut case to reference as to sort of how that would play out if someone did go to court. To the best of my knowledge, that might exist. I'm not familiar with it. It would default to their enslaver. That's who would technically own it, right? Because anything produced by an enslaved person was the property of the person who enslaved them. However, in the case of Hammond, it seems that the proceeds of that publication, I don't have the records from his printer. I can double check the pictures, the two printers who originally do it. It doesn't seem that they, in 1787, asked for a copyright. Again, those records all burned, so if they did, we wouldn't know it. But certainly by 1807, when Hammond's work is reprinted, there's no copyright debate about it. If there were any proceeds, they probably would go to the organizations by which enslaved people often wrote for. So Hammond's writing, right, was for a sort of forerunner of the New York Manumission Society. That's who he was doing his writing on behalf of. So if anyone was going to raise the proceeds, it was probably them. It's unlikely that Hammond's enslaver created sort of a deal with the printers. It's more likely that proceeds would have gone to that group. And it is, of course, possible that enslavers at various points, and I think later on in the 19th century when we get other kinds of publication, might arrange for some kind of like interpersonal situation, like, oh, if you were enslaved, the enslaver, you could negotiate, keep the money or something like that, but that would all be informal. That wouldn't be legislative.
Okay.
But yeah, but the very short answer is the person who enslaver.
Okay.
Yeah.
Okay, back.
Hi, I'm Rosie, I'm also a master's student. I was just interested, you picked up on the his and hers of the law. This might be going slightly beyond the scope of this talk a bit, but do you know how like women writers in other states then negotiated the very gendered element of their copyright, state copyright law?
Yeah, those are both great questions. And if you are interested in this at all, Melissa Homestead has a really phenomenal book on that. It's really, really good. Basically, the other state laws, when women do, and again, they're not overwhelmingly popular. I really should probably emphasize, like, it's a relatively small pool, hence my abstract, small pool of writers, of people who are drawing on these laws. But in that small pool, women writers were accessing them, even though the pronouns were gendered explicitly now. They were choosing much like other rhetoric of the period about sort of political liberties to interpret gender quite loosely there. So because we don't have those 1912 records, it's the records that were destroyed, it's really hard to know if people who were filing for copyrights under the New York Act did make note of it. Another wrinkle of it too is that because the legacy of copyright, right, is that more printers were using it, and because more printers were male, right, in this period, that would probably indicate that there wasn't going to be a lot of attention paid to that. And yet, because it is so unusual, it kind of begs the question, like, why did they do it? It doesn't seem like an accident. So why? But maybe the person then to wrap up my rambling answer to your excellent question on is that Mercy Otis Warren, just a few years later, and Rosemary Sagari talks about this too, talks about that she does register for copyright, and she registers for it early and repeatedly because it's, quote, the only thing she can properly call her own, right? Coverture is very much still in existence, right? And she wants to leave her writing. It's all angry copyright. It's worth noting, the Act of 1788 does gender. And you know how you know it's on purpose, because by 1793, it goes back to just being king.
So that's a whole other, but that's for someone to do a project on patents, which are a whole other thing.
I was just curious how they recognized patents across the Atlantic after the Revolution.
Oh, okay. Patents across the Atlantic after the Revolution. Yes, okay. So patents, what makes, sorry, it might seem like a long way to get to the answer, but I promise I will get there. Patents in the US are distinct from patents in England in the fact that patents, as we associate, I'm just gonna make up words, associate them now, right, are very much tied to technology, but of course there is the long legal and commercial history of patents being tied to land, right, letters patent, different kinds of recognitions, land ownership, and then over the course of the 18th century and parts of the 17th century, right, it morphs into these technological grants as well. In England, the wellspring for patent law, like where technological and scientific patents come from, is entirely separate than the legislation where copyright comes from. Like the laws are totally different. But once you get to 1790 in the United States, they're put in the same place in the Constitution, so 1787, they're put in the same place. So that's a pretty substantial break from legal practice in Europe and in England specifically, because they're not technically, they actually do function quite differently, right? Like the phrase that I was taught in school was copyrights are, patents do, right? They have fundamentally different purposes, right? Because copyrights just are. You made the thing, now you have it. Patents are a continual process, they're doing something. The Millwright's Guide is a really great example of this. There's a guy who writes a guide to building a mill turbine. He gets a patent for the turbine and he writes a guidebook on how to build the turbine. And he gets a copyright for the guide, and then gets really annoyed that people start buying his book and making their own turbine because he had the patent, but you wrote the book telling people how to do it, right? So they're two different things here. They're not the same, and one is going to get you a very different result than the other. So when patents, so I guess what I would say is patents moving across legally are quite different in the United States. However, technological piracy is, which is a bit of an anachronistic phrase, it wouldn't have been viewed quite in those terms yet, is rampant. And it's like this is a cornerstone of Hamilton's financial plan, might not be written that way, is technological piracy, right? That's the irony of, he's a copyright lawyer who's advocating for patent piracy. Again, it's very separate. And there's a book by Doran Benatar called Trade Secrets that goes really into depth about that. But that's, I'll stop there before I ramble on.
Okay.
I know it. Version of one of these chapters to see the whole project. And I'm curious in thinking about Peter Williams and Jedidiah Morse and just how, on the one hand, there's very much a racial dimension to how they approach their defense of their work. But I'm curious if, in looking at the similarities between them, if it's worth talking at all about how copyright is not reactive necessarily, but very proactive, at least as the century goes on, because I'm thinking about Lewis Evans, who is writing during the period where like he sees a lot of plagiarism, and so that's why he's like, I'm gonna put this on there and we'll see if it holds. But with these guys, they take different strategies to be proactive, but I'm curious if that's part of this kind of self-fashioning.
Yes. Yeah. Sorry.
I hope that makes sense.
It does, yeah. So in other words, right, how, when they're kind of maybe on the other end of it or the other side of it, right? And the reality is that, and this is probably where the intention or the goal of how you're using copyright really matters, right? If people he's not going to become litigious if people reprint information. Where he might potentially become litigious, right, is as you see further down the road in the 19th century, right, when Black authored publication is misappropriated, right, in really insidious ways by sort of pro-slavery, right, actors. Barring a situation like that, and there are examples where that overlaps with copyright in really interesting ways. I do a hard stop on 1834 precisely because the landscape begins to shift, I think, fairly precipitously. And again, Meredith McGill
is incredible on this, but Joanna Brooks, Susanna Ashton, Joe Resnick, those names really need to be out there for how they look at that process. But barring that kind of situation, copyright is not being deployed to stop reprinting by Williams. It seems, and that kind of, at least for me, when I see that, and I'm like, okay, so copyright's not really effective at stopping plagiarism in this period, right? It's just not. So why are they bothering, right? Why are they putting in the time and the effort to do it? And sure, maybe on the off chance, like Evans is like, all right, I'm gonna throw this at the wall, I'm gonna see what sticks. But by the 90s, by the early Republic, it's a little bit more than that, I think, as opposed to Morse. When Morse is plagiarized, Morse goes to court. Morse goes to court, and Morse goes to court, though, perhaps not entirely for the reasons you might say. When I'm about his case, I was expecting kind of something a little bit different. He is really mad at the person who reprints. Basically, there's this man, and I'll keep it short, but there's a bunch of people who are in like Atlantic world, right? So this guy's in England. His name is William Winterbotham. I'd say that name, but William Winterbotham, and I just talked about this over the summer at a different conference, but is like repulsive to Morse in every possible way. He's a Baptist. He's pro-French Revolution. He's basically Jacobin. I mean, like he is everything that a high Federalist congregation in New England is gonna like. It's just gonna set his already prone to nervousness just off the charts, right? It's just horrifying to him. And the way he describes it, he's mutilated my text. He uses the word mutilation. He's mashed it up in such a way that it no longer bears resemblance to what I had intended. But wait, this is why everyone should check out the Bad Art Friend episode. But if he's mashed it up in such a way that it no longer resembles what you've intended, well, then theoretically it should constitute a new work, right? It's different. Why would you worry? And yet, he knows that everybody knows that it was his because William Winterbotham rattles off a list at the start of his book of all the American authors he's cribbed from. Because he's not embarrassed. He doesn't think he's doing anything wrong. So this just puts him into a complete tailspin because people are going to know it was him, but they might think he likes the French Revolution. They might think, right? They might, I wish it's the poor guy. I mean, I'm like, okay, really nervous. But so he pursues this man who he cannot sue in court. I should have also noted this at the beginning because copyright is bound, again, by land. He cannot sue Winterbotham, who's sitting in jail as he's writing this book for libel in London. It's anyway. So he sues the guy who reprints him without Winterbotham's permission in New York because he's so concerned of the image that this is going to leave on his reputation. And you know how you know it's about reputation? He wins. Hamilton gets him the money, and he gets him a fair amount of money. He turns the money down. It's only going to take a little bit of it because it will ruin John Reed's family if he takes all the money. Right? It's not for him, and this is also, Morse is very flush at this time. He's doing really financially well. 10 years later, he might not make that choice. But at the time, he's like, I only want to cover what I need to basically cover, even though it's a pro bono case, Hamilton does it for free. Some minor expenses related to it keep. It still ruins Reed anyway because he's already made all the books and now he can't sell them. But it's not the money. So that I think is that's the difference in reaction that I would say.
A current situation a few years ago, some of the writers, the opinion writers in the New York Times were suing because they felt their work should be copyrighted, that they were authors, they were both writers and authors. I don't remember how that turned out. Can you address that?
It's familiar. Thank you for bringing that up. Yeah, it's familiar to me, and I'm going to do this yet again. Will Slaughter, if anyone's interested in the relationship between journalism and copyright, and he goes far up. He goes into properly into the 20th century. But they're like, and you articulated that so perfectly, like the writer. It's not like creative nonfiction, but it's obviously opinion, it's one's interpretation of fact or evidence, right? It's unabashedly so. It's unabashedly an opinion page. And yet, how does that qualify, right, as sufficiently, but because it's published by a news outlet, it's kind of that question of like, if you're a map, well, I'm not looking at the wrong slide, but if you're a map maker, right, and your work is subsumed within the bigger volume, and I'm not sure, unfortunately, how that case turned out, but it's going to keep coming up, I think, especially as some of the financial imperatives that journalists and news publications have to deal with become even more challenging. But if you were, for example, if you're Gail Collins and you publish a collection of your op-eds as essays, there's probably not going to be an issue with that. Or maybe you have to deal with the times, but that's not going to be a copyright issue externally.
My apologies if you mentioned this already, but was that a uniquely New York phenomenon, or were there other efforts to use copyright as a tool of censorship?
Oh, in the 67, I say the 68 law, the 1768 law, more recently. That is the only time that I have found it in pre-1834 copyright law in the United States. That said, there are some instances, and I have not studied it enough, hopefully down the line I'll get to look into it a little bit more, but there are some examples in England in the 1830s and 1840s of the libel inroad into copyright. It's largely around smut and pornographic publication. That's usually where you see people losing the copyright to the work. In a really strange twist of fate, though, the person who ends up going to loses the copyright for their licentious publication in the it's 1830s or early 1840s in England is actually the son of Morse's English printer, John Stockdale Jr. That's how I found it. I was looking for the wrong Stockdale. And I was like, wait, this kid, and I was like, oh, it's 30 years later. That explains it. But that's an example where it does come up. Certainly later in the 19th century, the 20th century, the connection between libel and copyright becomes much more explicit. But that's the only time I encounter it in this earlier period. And no one seems to do anything with it. It doesn't really seem to go anywhere. That's probably because it's superseded by the Sedition Act and other laws involving it.
Thank you.
Sure.
I just had one question
Yeah,
about
yeah.
this. I mean, I don't know if it comes fully after the time period of your project, but this transition from this being about the civic or communal or kind of broader good, and that's why copyright is being invoked and kind of process. When does it become something that's tied to more individualistic, less caring about kind of the broader collective? And I also was just curious, I mean, is that something that's being, is that rhetoric just in the American case, or is this something that we see in other continents?
Oh, that's great. Yeah. So the first answer, I could be super long-winded or super short. Legally, and I wish this is where I wish I had a JD, but I think I heard that there are some JDs in the room. Legally, it's 1976. You have the advent in 1976. There is a sort of seismic overhaul of copyright law that begins in the early 20th century and really culminates in 1976. And you have sort of the official rise in that period of what sort of common term is like corporate copyright, but there's a host of other legal doctrines associated with it. And forgive me because I don't have I'm not trained in that. I can't speak to it more. But in effect, that's where the rhetoric begins to markedly shift. Where you sort of lose the prologues of equity and enlightenment and these other things, and that has shifted pretty dramatically into copyright period becomes so much longer, becomes so much more extensive, and also the proprietor, if you will, to use the 18th century term, really becomes the dominant fixture as opposed to the artist. In terms of the second question, it's not a solely US phenomenon. You definitely see it, Statute of Anne. I think the long name of the Statute of Anne is tied to encouragement. It's encouraging learned men to like produce, I think it's like enlightened works or something like that. But to the best of my understanding, it tapers off a little bit sooner. In the United States, that rhetoric lasts like well across the 19th century. It comes up as a really famous, one of the really landmark Supreme Court cases about Harriet Beecher Stowe and a German translation of Uncle Tom's Cabin, and that just is there. And so it stays, I think it lasts a little bit longer in the United States, but I should also say I'm much more familiar with the US. It is in England though, it is in Scotland, but I think it shifts because you have the stationers, you have other, and I mentioned at the start of my talk, but you have trade courtesy in the United States in the 19th century, right, which is printers kind of mimicking or reflecting aspects of copyright law, but as it suits printers very specifically and publishers, and that I think starts to supersede that a bit in the UK too.
Well, do we have any more, or are people kind of jonesing to get to a happy hour? We're to the Pursuit of Happiness hour all the way next. But if we can all thank Nora again one more time.
Thank you so much. Thank you so much. It's wonderful. Thank you, Zoom.
Yeah, get started.